The moment you open that door, you may have already lost your Fourth Amendment rights. Everything inside your home, your personal belongings, your private life, your entire world becomes visible. And you did it voluntarily, because nobody told you that you did not have to. This happens to law-abiding Americans in every state, every single day. Not to criminals. Not to people doing anything wrong. To ordinary people who simply did not know the rules. By the end of this video, you will know exactly what police can and cannot legally do at your front door. The Fourth Amendment has been part of this country since 1791. Over 200 years ago, the founders wrote a protection directly into the Constitution that says the government cannot invade your home without judicial authorization. That protection still exists. But the Department of Justice has documented widespread confusion among the public about when it actually applies. The ACLU has reported for decades that most Americans do not know their basic rights during police encounters, including encounters at their own front door. This is not taught in public schools. It is not printed on your driver's license. Nobody hands you a card that says, "Here is what the law says about your home." The system does not volunteer this information. That gap is exactly what leads to searches that never should have happened, and to evidence being used in court that should never have been collected. What you are about to hear changes that. The foundation is the Fourth Amendment to the United States Constitution. Ratified in 1791, it guarantees the right of every person to be secure in their house against unreasonable searches and seizures. It does not say most of the time. It does not say unless police have a good reason. It says unreasonable searches are prohibited, and entering your home without a warrant is, by default, unreasonable. The Supreme Court made this crystal clear in Payton v. New York, decided in 1980. The court ruled that the Fourth Amendment prohibits police from making a warrantless and non-consensual entry into a suspect's home to make a routine arrest. The home, the court said, is the most protected space under the Constitution. Police need a warrant to cross that threshold, period. What this means for you. If police show up at your door without a warrant, you are not legally required to let them inside. Now here is where most people go wrong. The first layer to understand is the knock and announce rule. Police are allowed to knock on your door and speak to you. That is not a search. They can stand outside and talk. But here is the critical distinction. The moment you open that door wide and step back, you may have just given what courts call implied consent. Courts have held that certain body language and behavior can signal voluntary cooperation that waives your rights. Practical meaning: do not fully open your door. You can speak through a closed door or a cracked door with a chain lock still engaged. The second layer is the warrant requirement itself. A search warrant must be signed by a judge. It must describe the specific place to be searched. It must describe the specific items police are looking for. It is not a general permission slip. If an officer says, "We have a warrant," you are legally allowed to ask to see it and read it carefully before allowing entry. What this means for you: ask to see the warrant. Read it. If it says 123 Main Street, Apartment 4, and you live in Apartment 3, that warrant does not cover your home. This next part is critical. The third layer is the exception doctrine, and this is where the law gets complicated. The Supreme Court has carved out specific situations where police can enter without a warrant. The first is called exigent circumstances. This covers genuine emergencies, a situation where police believe someone inside is in immediate danger, or where they are in hot pursuit of a fleeing suspect they just watched commit a crime. The second exception is consent. If you say "come in" or "sure, go ahead," that is legally valid consent. It does not need to be in writing. It does not need to be read to you like Miranda rights. You said yes, and that yes can be used against you in court. What this means for you: the word "sure" can cost you everything. Do not consent to entry, ever, without a warrant. The fourth layer involves the plain view doctrine. If police are lawfully at your door and they can see contraband or evidence of a crime from where they are standing, without entering, they may be able to act on what they see. Their presence at the door was legal. Their eyes were in a lawful position. That evidence may be admissible. What this means for you: What is visible from your doorway matters. Be aware of what police can see from outside before you answer. Marcus is a 34-year-old electrician living in Houston, Texas. It is a Tuesday evening. He just got home from work. He is still in his work clothes. There is no crime happening. There is no reason in the world for what happens next. Two officers knock on his door. They say a neighbor called in a complaint about noise. Marcus, being cooperative, opens the door all the way. He steps back. He says, "Sure, officers, come in." He is nervous and does not want trouble. One officer steps inside to look around. The other stays in the doorway. The officer notices a small bag on the kitchen counter. It contains a legal amount of a substance that is legal under Texas law, but it is sitting next to a scale. The officer says it looks like distribution paraphernalia. Marcus explains it is for portioning out coffee. The officer does not care. Marcus is detained. The apartment is searched. His night and the months that follow are destroyed. Marcus never committed a crime. He just did not know his rights. Now let us rewind. The officers knock. Marcus does not open the door fully. He speaks through the door and asks, "Do you have a warrant?" They say no. It is just a noise complaint. Marcus says calmly, "I understand. I do not consent to entry. If you need something further, please contact my attorney." He does not slam the door. He does not yell. He is polite and firm. The officers cannot enter. There is no warrant. There is no emergency. There is no exigent circumstance. They leave. Marcus's home was never searched. Nothing was seized. His life continues undisturbed. The only difference between those two outcomes is 5 sentences of legal knowledge. The first mistake is opening the door completely. Most people do it automatically. It is a social reflex. But fully opening a door and stepping back has been interpreted by courts as an invitation. You can speak to an officer without ever opening that door more than a crack. The second mistake is saying, "I have nothing to hide." People say this because they believe it proves innocence. Legally, it proves nothing, except that you are willing to waive your Fourth Amendment rights. You never have to prove your innocence at your own front door. Even more dangerous is asking, "What is this about?" before asserting your rights. The moment you start engaging with the substance of their visit, you create a conversation. That conversation can be used to build probable cause. Probable cause means a reasonable basis to believe a crime has occurred. Give an officer enough small statements, and they may have enough to justify further action. Here is one almost everyone gets wrong, assuming a badge means a warrant. Officers have legal authority to investigate. They do not automatically have legal authority to enter. Those are two completely different things. An officer can be completely legitimate and still have zero legal right to cross your threshold. The final mistake is consenting out of fear. Fear of seeming guilty, fear of making things worse. But consenting when you did not have to is one of the most legally damaging decisions a person can make. If police knock at your door, do not open it fully. Speak through the door or through a chain lock crack. Stay calm. Stay polite. Do not raise your voice. If they ask if they can come in, say exactly this: "I do not consent to entry into my home." If they say they have a warrant, ask to see it before you move. Say, "I would like to see the warrant before I open the door." Read it carefully. Check the address. Check what it authorizes. If they claim there is an emergency, do not argue it in the doorway. Let them articulate what the emergency is. Do not create a confrontation. If they force entry and there was no valid exigent circumstance, that is something your attorney addresses in court, not you, alone, in the moment. If they continue to pressure you, say clearly and calmly, "I am asserting my Fourth Amendment rights. I will not consent to a search. I am happy to cooperate through proper legal channels." Then stop talking. Saying these words is not aggressive. It is not suspicious. It is not the behavior of a guilty person. It is the behavior of someone who knows the law and has chosen to live inside its protection. The Fourth Amendment protects your home from warrantless entry, and it has since 1791. The Supreme Court confirmed in Payton v. New York that police cannot enter your home without a warrant to make a routine arrest. Exigent circumstances are the exception, not the rule. Consent is the most common way people accidentally surrender their rights at their own front door. You are never legally required to let police inside without a warrant. You can be polite, calm, and completely firm, all at the same time. Your home is the most protected space in the entire United States legal system. Now you know how to keep it that way. This video is for educational purposes only and does not constitute legal advice. Laws can vary by state and by individual circumstances. If you are facing a legal situation, please consult a licensed attorney in your state. If this helped you, someone you know needs to hear this too. Most people will go their entire lives without knowing what you just learned in the last 10 minutes. Share this video. That is how this information reaches people before they need it, not after. Subscribe so that the next time you face a situation like this, you already know what to do. Knowledge is the only protection that works before an encounter happens.